go on the record for this?
Yes.
Good morning, Your Honor.
Just a second. Let's go on the record on cause number DC 209893. And Tony, I want to go on the record on the court reporter record too. David Tyler Moss versus Marco Princip all. Counsel, make your appearances.
Good morning, Your Honor. This is Hunter Nunn, N-U-N-N, and almost Warrants from Warrants and Nunn for the plaintiff's judgment creditors, David Tyler Moss and Fidelissimos LLC.
Good day,
morning.
Judge. This is, oh, go ahead. I'm sorry.
Good morning, sir. Dan L. Wide for the judgment creditors, Moss and Fidelissimos.
And there's another gentleman on the phone. Could you state your name?
Yes. Yes. Good day, Judge. This is Jamal Johnson with the law firm of Alex Fernandez on behalf of Brian Martin.
So I'm showing you guys the screen here. This is from the our Dallas County portal. I don't see that there's been a notice of appearance from the Hernandez firm on this case. Have you guys filed a notice of appearance, and maybe it's not up? And if you have, I'd like to have you share screen it.
We've just come on board 2 days ago, sir. And that's a part of the reason why we're asking for the continuance.
But have you filed it? But have you filed a notice of appearance?
Not at the moment.
I can't even really listen to you filed it until you filed a notice of appearance.
Okay. I don't believe one is on the record, but we are making an appearance here at this hearing, and we intend to file that notice today.
Okay. What do y'all want to do about, I mean, generally, my position is if you haven't filed a notice of appearance, you're not in the case because
Yes, sir.
we have no record. We don't know who you are. We don't know if you're an attorney or not. I mean, we don't know anything about you if you haven't filed a notice of appearance. But
Sure.
if the other side is okay with it and wants to move this hearing, I'm okay with that. But that's my general approach. If there's no notice of appearance, the attorney can't appear.
Your Honor, if I may, I'd like to go ahead and proceed this morning.
Are you objecting to I'm sorry, I keep forgetting you said it was Jamal something and then with the Hernandez.
Jamal Johnson, but I'm with Alex Hernandez. Alex Hernandez is the firm that's hired, and we're going to make a notice of appearance today. But we definitely want to make an appearance on behalf of the client as we are hired by the client.
What is your feeling about that, Mr. Wide?
Well, we would respectfully request the court continue on the motion to compel. We anticipate, if I'm correct, Mr. Nunn and Mr. Warrants are going to ask you for 7 days for them to provide this discovery that we've been waiting for since last July, or this past July, give or take. I think it was due late August. Mr. Martin had counsel and he fired earlier in this matter. And if they would like to file a notice of appearance this afternoon and work with Mr. Martin to provide the requested discovery within the next 7 days, that would be fine with us. But I will tell you up front, Judge, it's not in my DNA to be anything other than really very candid with the court. Mr. Martin has never cooperated with us, and we have no reason to believe he ever will. And if you read the petition that was recently consolidated pursuant to your orders earlier this week, that's now in your court, you will see that time and time again, we've requested this financial data from him, and we never get anywhere. And he's currently hiding out. We have no physical location for him. So I don't think and I have nothing against Mr. Johnson. I've never met him. I don't know the Hernandez firm, but I would suggest to you they don't have clean hands, so to speak, to ask you or plead for anything right now. And I will then defer any further comments to Mr. Nunn and Mr. Warren.
I guess and I appreciate that, but
Yes,
I guess my issue is, do you object to Mr. Johnson even being here, like responding to this because they haven't filed the notice of appearance?
Your Honor, yes, we do so object. Thank you.
Okay. Mr. Johnson, if you want to, file and, I don't mind if you were here in person, I would let you write it out. But if you want to e-file it and email it to my court coordinator right now, I'd be happy to allow you to speak. But since we don't know, and I'm not questioning you, it's just there's nothing in the system to indicate that there's an attorney for Mr. Martin. But if you want to do that real quick while we're in the hearing, I'd be glad to let you talk. But we need a notice of appearance. So,
Okay.
All right.
Is there an email address that I could?
Sure.
Can I call?
Rhonda, can you put that in the chat? So Rhonda will give you her email address. All right, let's go forward with the motion.
Yes, sir. May I proceed?
You may.
Thank you, Judge. May it please the court, I want to thank the court for its time this morning and for the opportunity to be heard. Judge, this is a very simple matter, really. We've got a judgment enforcement action pending in your court, the domestication of a judgment from United States Court against Mr. Martin. We sent post-judgment discovery to Mr. Martin on July 29th. It was e-served to his counsel at that time, Adrian Bauer. As of today, we have not received any response from Mr. Martin. That's obviously a problem for us on, I believe it's 34 interrogatories, 43 requests for production. The only document that he's produced at all is a document that purports to be a 2018 tax return. So, Judge, we're here to ask the court to order Mr. Martin to answer these interrogatories in full without objections, to respond to the request for production in full and produce all responsive documents to me at my office within 7 days.
Okay. Mr. White, did you want to say anything?
No, sir. I do think no, at this point in time, I'll defer to, like I said, Mr. Nunn and Mr. Warren, if you will, sir. I didn't hear all the other announcements. I apologize, Judge. I was preparing for a hearing right after yours, and I don't know who Mr. Lee represents, and I don't know about Miss Dominique. I mean, Miss Lee, Stephen Lee.
Mr. Lee, I assume you're on my next hearing. You're not on this one, correct? You're muted, sir. You're muted. He's talking, but he's muted.
Yeah, Judge, I'm sorry. I was muted. I don't have a dog in this fight. I'm here for the next hearing.
Miss Lynn Rada, what are you here for?
Miss Rada is in my case, Judge.
Your Honor, I apologize. Let me get, I'm on the hearing with Mr. Lee.
Okay. And I think everyone else here is an intern.
Oh, okay.
We have Miss Lee, Miss Simmons, and Mr. Sharp. So, all right, Rhonda, the court will go ahead and grant the motion. I don't see that you guys filed an order on the compel, did you?
We have not yet, Your Honor. I'd be happy to do that as soon as the hearing concludes.
All right, Rhonda, can you check the email to see if we have something from Mr. Johnson?
Judge, I still did not see the email address, and I'm having to actually draft a notice of appearance impromptu. So I don't see an email address to even send it to once it's drafted.
Let's see. I'll stop sharing, check the chat. So it's right here in the chat. She posted it
Right.
minutes
So
ago.
so I was initially engaged via phone only, and I just logged on my computer, and I don't see any chat history. I only see an empty chat box.
Yeah, why don't you resend it?
Judge,
Anyway, why don't we do this just to give Mr. Johnson a chance to kind of catch up? So why don't we give him 10 days total? So, or whatever the Monday is after next, so we'll have 2 weekends to get this done. So let's have it due on October 12th.
Yes, sir. And Judge, if I may, we did ask for attorney's fees in our motion, and I'd like to very quickly present evidence on those if I may.
Okay,
Yes, sir. May I proceed?
you may.
Your Honor, my name is Hunter Nunn. I represent the plaintiff's judgment creditors in this case. I've been a licensed attorney in Texas since 2012. My practice includes plaintiff's personal injury work, commercial matters, and also real estate matters. Your Honor, my going rate these days typically for my time is $350 an hour. And in this case, drafting the motion to compel took me a little over an hour to prepare. The proposed order that we're going to file today took about half an hour to prepare. I've got about half an hour in preparing to appear for the hearing today, and a couple of phone calls here and there with Martin while he was not represented to discuss the issues that we set forth in the motion. Unfortunately, those didn't really get us anywhere, which is why we're here today. Judge, I'd like to ask the court for $1,000 attorney's fees for my time on this motion.
Rhonda, do we have notice of appearance? Okay, it doesn't seem like we do. All right, so the court will grant, no, we don't have one according to Rhonda. All right, well, we'll go ahead and grant the motion for sanctions to be made payable at the time. Well, I guess we already have a judgment, so, you know, and I'm going to give Mr. Johnson a chance here. I'm going to require $1,000 to be paid in 10 days unless adequate answers are filed in that time period. So if they file adequate answers that, you know, let me say instead of adequate, full and complete answers within 10 days, then the court is not going to award sanctions. If they do, if they don't file full and complete answers, then the court will award $1,000 in sanctions.
Judge, may I broach a subject with the court that I have not had any experience with on the civil side?
Sure.
If it's appropriate. Has the court, can the court provide any guidance if a party to a civil action basically flees the country?
I mean, what are you asking exactly?
Well, obviously on the criminal side, you could, you know, amend bond conditions of bond. If somebody was on bond, if they're incarcerated pending trial, they're not going to wind up fleeing the country. But
Right.
Mr. Martin has indicated that he either is living in England or he is going to flee to England. And that's a problem, you know, and I don't know if the court has ever had that experience before in other cases and how you may have handled it without committing you to any.
You're asking a really big question there. I mean, a very broad question. I think that you need to realize in this particular case, it's about collecting a judgment. And so what you need to be doing is trying to find assets here or find assets, whether it's here in the United States or elsewhere, and start executing on those assets. I think I've made it very clear that I'm willing to do that if it's appropriate, if we can show that they're owned by the judgment creditor or judgment debtors. But you just have to be able to prove what exactly is owed and is there fraudulent transfers and things like that. I don't think it's a good strategy by Mr. Martin to do that, because if he doesn't have a voice in this process, I'm probably going to be a little bit, if you only hear one side of the story, you're more likely to go with that side. And so the idea that he's going to somehow be able to escape justice because he moves to, especially if his main assets are electronic, we could enforce that here in the United States all day long. And he doesn't necessarily even need to be here if he's deciding to kind of flee the country. Now, it will be more difficult, obviously, to enforce contempt hearings against him, to imprison him if that's what needs to happen. And I've only done that in 2 cases that I've been involved with, that we don't put people in jail as often as you usually do over in criminal court. I have done it, but I think obviously my thought would be that you guys want to be focusing on, okay, I need to find his assets and execute on them. And you don't necessarily need him here to do that, especially if his main asset is, YouTube channels and proceeds from YouTube channels and things like that.
Yes, sir. And I'm fond of making a bunch of trite sayings from time to time, but I'm not involved in any case where I'm trying to set court policy. We want to, I encourage and I counsel my clients, we're going to do business the way the court decides to do business. We don't do business as private attorneys the way we want to just do business. And so I hope you understand, having not been before you in the past and being entirely familiar with how you handle certain circumstances, we just, while you can't give us advisory opinions and tell us how to practice law, I think we all know that, but
Sure.
I just wanted to know, in my 30 years, and especially just the 15 in private practice, not all that long, but I have not come across this situation in a civil matter, and just don't have an idea really about how various judges would normally kind of handle that.
I'm going to follow the law on this.
Yes.
And so there's going to be issues potentially with the Hague Convention and all that kind of stuff to be able to get service on him if he goes to England. But the advantage you have is this is a post-judgment action. And so if he doesn't respond, he's already subject to jurisdiction here, in my opinion. And so you can just start executing on his asset and taking it. If he doesn't want to participate, that's, I think, a huge mistake on his part to do that, because, and I imagine once you start executing on these different assets that he has, these YouTube channels and proceeds from that, and all that kind of stuff, that there'll be people who will show up and say, hey, wait a minute, that's not his, or whatever. If that's the case, I don't know what the case is. Or he might start showing up and go, hey, I was getting $10,000 a week and now I'm not getting anything. Maybe I need to participate in this process. I think it would be very short-sighted and unwise of Mr. Martin to not participate in this process to make sure that his interest is represented. But there's a judgment already, so we're just going to start enforcing the judgment if he doesn't want to participate. So, all right. There's a Holly Martin here. Is she involved in this case, or is that somebody else? She just showed up.
We definitely would like to get her contact information, Your Honor.
Well, she just showed up on the.
She's a citizen of the United Kingdom, and all we have is a green card. And if she's making an appearance,
all I know is that I saw her on the Zoom. I don't know anything else on what she's doing. I just saw her on the Zoom, but she hasn't. Are you Holly Martin?
Brian Martin, Your Honor.
Oh, you're Brian Martin. Okay, well, I was just talking about you. So apparently your attorney's not here. or your attorney, you hired an attorney, I guess, but hasn't entered an appearance yet. So, but we just granted a motion to compel against you. Are you here in the United States, or where are you?
I'm actually moved to the UK with my British wife. Your Honor, my reason is Dan White is treating this as a criminal case. He's been abusive with my wife and myself. He's that he wants to throw people in jail than to collect the judgment. My wife moved to the United States to start a life in the United States, and she fled the United States because she's afraid of the system. And I had to go with her because we're both autistic. We have mental problems. And so we wanted to, I had to go with her. I came on here, Your Honor, because I wanted to defend myself against Dan's allegations. I'm not hiding. I don't want to waste the court's time. That's why I've hired representation so I can properly defend myself, despite that I have moved, Your Honor.
And what I was saying to Mr. White and to your attorney, who hasn't officially made an appearance yet, or person I believe, is it Mr. Johnson that you hired, or the Hernandez firm?
Yeah, Alex Hernandez Jr., Your Honor.
Obviously, they're concerned that you've moved to the UK. What I've told him is that this is a situation where they're trying to execute. They're going to try, I assume, going to try to execute on all of your assets, non-exempt assets, including, I guess you may have a YouTube channel and some other things. I don't know all the details. And I told him I thought that would be very unwise for you to not have representation, and for whoever owns these entities not to have representation, because there's already a judgment against you. I have nothing to say about that other than my job here is to make a determination of which of your assets are exempt, which of your assets are not exempt, and then what's owned by you and subject to levy. And so you moving to UK, I think, may actually put you at a bit of a disadvantage, because it's going to be harder for you to defend yourself here. But that's your choice. If you decided you wanted to do that, if you felt like that, but that's not going to keep the levy from occurring. They're going to continue to levy on your assets, and and if there's assets in the UK, we'll work on getting levies on that. Well, assets here in the United States. But that's where we are in the process.
Yes, Your Honor. If I may, under oath, I would like to say that I do not own any YouTube channels. In 2017, they tried to do this again with these YouTube channels and say that I owned them, and the motion was denied also by the federal judge, and they're continuing to harass other YouTube channels, Your Honor. They said that they would go after any YouTube channel that the video games YouTube channel worked with, Your Honor, and it just feels like a big witch hunt.
May I have a moment of the court's time?
I've already ruled on, there's one motion that's here. There's a motion to compel. I ruled on the motion to compel.
Yes,
I granted the motion to compel. I'm not ruling on any of this stuff. Right now, Mr. Martin, you have the obligation within 10 days to answer their motion to their request for their discovery request. If you don't answer those, you'll be sanctioned. If they attempt to levy on this YouTube channel, then it's going to be up to whoever owns that or you to say who is the owner, and is there some type of fraudulent transfer, which I think is what they're alleging, if I understand. But nothing like that is being decided today. You are far better off Mr. Martin, to participate in this process and defend yourself, and whoever owns these YouTube channels, if someone else does, they should participate in this process. But I guess I don't really have anything else to say, but that's what we're doing today.
I asked the court to note that he's made an appearance at the motion to compel hearing. And consequently, if we ask the court for guidance on if Mr. Martin terminates counsel and we have to have substituted service, at this point, what we're asking, which is what happened in July, if you will, or August, which is why we have alleged new counsel, Mr. Johnson. But he's made an appearance now in this hearing. And we ask that the court note that he's made that appearance.
We're on the record, Mr. Wyde, so that's already going to be noted. And
Okay.
sir, if you could state your full name so the court reporter gets it.
Mine, Your Honor?
Yes.
It's Brian Dennis Martin, Your Honor.
Are we
Did you
entitled?
want something specific from him? Because I know you wanted to serve him maybe via email or YouTube, or not YouTube, Facebook or something. Is that?
Email and street mailing address, regardless of where he's living and what country.
I'm currently in a hotel right now.
What is your email address?
My email address, Your Honor, is xbrianmartinx@gmail.com.
And what hotel, may I ask?
I'm in a Premier Inn hotel.
And the street address, please.
I don't know this street address.
In what city?
It's in Clacton,
Please spell that for the record.
CLACTON.
And what province or state?
I'm not familiar with that type of geography.
Do they have provinces and states in the UK? I don't know that they do.
Okay,
I've
so
heard
it's
of
just
that.
Claxton, what country?
It is in the United Kingdom.
And what country, sir?
Is this
United-
Clacton on Sea in England? In Essex, England, Clacton on Sea?
Yes,
In Essex, England?
yes.
Thank you.
And is
All right,
Miss-
guys, I really need to get to my next hearing. So anything else we need to chat about?
No, sir, Your Honor.
Get me an order on this, Mr. Martin and Mr. Johnson. I would strongly urge you to comply with the order, and we will see you at the next one. Oh, I see that Mr. Johnson is raising his hand.
No, that was an accident. I was trying to unmute myself.
Okay. That was a new one. All right, guys, thank you so much. You guys be safe, all right?
Thank you,
Good
Judge.
weekend.
Have a good weekend.
Thank you, sir.
Take care.
Okay, I think we have one more hearing. Is everyone here on the James Dodd versus the heirs or legal representatives of the estate of Tony Matthews?
Steve Lee's here for James Dodd, Your Honor.
R. Hamilton for CF Motor.
Stephen Bega for the Empire Company and Penske.
Lynn Rada on behalf of the estate of Tony Matthews.
Okay, so let's go on the record on cause number, Tony, you there? DC 199372, James Dodd versus the heirs or legal representatives of the estate of Tony Matthews. Counsel, make your appearance.
Judge Steve Lee for James Dodd, plaintiff, and it's our motion to strike.
E. R. Hamilton for,
Sorry, ready?
and E. R. Hamilton on behalf of defendant CF Motor.
Stephen Bega on behalf of defendants, the Empire Company and Penske Truck Leasing.
Lynn Rada on behalf of the estate of Tony Matthews, ready.
Okay, so I've read the motion to strike. Is it accurate that Mr. Chapman is not a doctor? Is not a medical provider?
That is correct, Your Honor. He is not. He is not a doctor.
I know that there is a case, I think out of Tyler maybe, that talks about whether or not a bill auditor can provide a counter affidavit. It has been my consistent practice to strike these in every situation where you have a bill auditor file one of these. And I've stated to many other attorneys in this situation, including one attorney who's tried this about 10 times in my court, that this is what I intend to do in every case. Until the Dallas Court of Appeals or Supreme Court tells me otherwise. But did y'all want to say anything else, or?
Well, I believe the Supreme Court has already said otherwise, Your Honor, in the Gunn v. McCoy case. I believe that in that particular case, they addressed exactly what we're dealing with before this court, where you had someone who is not a doctor who provided controverting affidavits, and they were allowed to stand. And that's 2018.
I don't think that's what Gunn says. You want to share a screen, Gunn?
I don't have it pulled up. I can pull it up very quickly, Your Honor.
And I'll allow you to share a screen. I just enabled it. Or does anyone else have that case and can share screen it?
I do, Your Honor.
Okay, why don't you share screen it?
Yes, sir.
All right, why don't we go down? Can you?
I think it begins, Judge, on page 672 is where they talk about the medical billing affidavits.
Okay,
Would the court like me to go to that section?
sure, that'd be great.
I know it begins on page 13, so that's why I'm going fast.
Okay. All right, keep going down. Keep going down. Let's see. So these are situations where the plaintiff provided record custodians from the health insurance for the affidavits. Is that right?
That is correct.
Okay. It doesn't, we'll keep going down. It doesn't address counter affidavits, or does it?
It doesn't, Judge. That's this one of the distinctions.
Right, because affidavits don't have to be provided by doctors. It's the counter affidavits that do.
Well, Your Honor, I'm not sure the case law holds definitively that counter affidavits need to be provided by doctors so much as it needs to be provided by someone who has who are qualified via their experience or education or training to provide the counter affidavit.
You know, I understand what you're saying, and I've had other defense attorneys argue that. I'm telling you that until the Supreme Court and the Dallas Court of Appeals tells me I have to allow these types of affidavits to be considered, I'm going to strike every one of them, and I've struck every one of them. Gun doesn't apply to counter affidavits. I didn't think it did, but I didn't remember. I haven't read the case in a while. So did you have anything else, or?
Your Honor, I would just like to point out, because I've yet to get to the part where it actually discusses where insurance agents are well suited to determine the reasonableness of medical expenses. And I understand the distinction between the kind of reversal of our argument here, but in terms of sufficient evidence to support either affidavit, I think that the court saying that insurance agents are well suited stands for the proposition that you don't necessarily need a medical doctor to come in and give these sorts of opinions. In our response and pursuant to the statute, there is no argument here about the medical necessity. We're not arguing that. We know that Mark Chapman is not qualified to argue about the medical necessity, but he is qualified to give opinions about the reasonableness of the charges. That's what we're discussing in this particular response. And it is a joint response, for all defendants in that regard. So, I mean, this is the paragraph here, starting with "we have previously," and just so that we have a full record, certainly would like the court to at least review this particular paragraph prior to making any sort of rulings.
Okay, which paragraph would you like me to look at?
Starting here, it says, "We have previously noted that agreements between willing providers and insurers can yield reasonable rates." Then it goes on to the end on the next page here on this paragraph. I can move up when you get to that point.
Go ahead. Right, it says, however, by drafting 80.01 to allow either a person who provided the service, okay, now you moved it.
Oh, sorry.
I've lost where I was. To testify to the reasonableness and necessity, the legislature has acknowledged and made allowance for the reality that the ideal paradigm does not reflect today's complex health system. I don't know that governs us. What else did you want me to look at?
Well, that specifically, and I mean, the court brings up a good point with respect to that paragraph, where it does talk about the complex health care system today, and that it says it's often influenced by insurance companies and by what treatments and procedures they're willing to cover. And that squarely fits in with the knowledge base of Mark Chapman in this particular instance.
Let me hear from the plaintiff's attorney. Do you still want me to strike these affidavits?
Of course, Judge. First of all, this case that they're citing, Guns, stands for the proposition that the plaintiffs under 1801 can file these affidavits, and the affiant can be a custodian of records or a non-healthcare provider. It doesn't address 1801F, which puts the burden on the defendants to provide an affidavit by somebody with the skill, knowledge, experience, etc., qualified to provide the affidavit. As you've noted in my motion, Judge, Mark Chapman is not qualified. He's not currently licensed. He's not currently certified. The data in his insurance base is vastly different from what they're talking about here in this paragraph that Mr. Vega pointed out. He is not using a national database created by an insurance company with offices and services nationally and regionally. He is using a self-created database, which he doesn't identify who the insurers are. And we don't know if they're providing services in the location, which would be Travis County, Texas, for the specific services we're talking about. And he's not testifying in terms of the usual and customary charges for specific HCPs, these providers that we have in this case, in this specific geographical location. So there's so many deficiencies with regard to Mark Chapman, who again, hasn't taken a continuing education class since 2001 and has been in private practice doing exactly what he's doing here since sometime in 2003. So I don't see how he's possibly qualified, but certainly Gunn versus McCoy doesn't give any authority for allowing these counter affidavits.
If I may reply, Your Honor.
Sure.
I'd just like to point out the language in the statute talks about knowledge, skill, experience, training, etc. All are part of any of the matters contained in the initial affidavit. So in this case, what we're specifically talking about is the reasonableness of the charges, not of the necessity. I'll agree with Mr. Lee in that respect. He's not qualified to talk about the necessity of the actual treatment. We're going to have experts give opinions as to those allegations, and our expert deadline isn't until the middle of next year to be able to do that. But what we're simply talking about here, Your Honor, is whether or not he has the skill or experience to talk about reasonable charges. And with all due respect to Mr. Lee, he is incorrect about the part about what his database can and cannot do. It can pinpoint charges in Austin, Texas. It can pinpoint any geographic region that is required to do so in this particular case. He has looked at evidence from Medicare charges, which, as you know, is a national program. It's not limited to any sort of geographical region. In terms of insurance carriers, you know, again, the same thing. I mean, there are national insurance carriers that, of course, include coverage in Travis County, in Dallas County, wherever, in Lee County, where this case was originally filed. So with what we're talking about.
Let me just say this. There's nothing that's, one of the things that I was told when I was a new judge is that attorneys want you to rule and the attorneys want you to be consistent. And so in every other situation where this type of matter has come up, I've ruled the same way. There's nothing there's been no change in the law. And I've said the exact same thing, which is until the Dallas Court of Appeals says otherwise, or the Supreme Court says otherwise, I'm continue to do what I've done in this case, which is I will strike these billing auditors or whatever you want to call them from being able to provide counter affidavits. And I've told attorneys what I will allow in situations if the deadline hasn't run is for doctors of the same area of specialty. For example, if a chiropractor wants to counter a chiropractor and testify that that this isn't, that I would consider those types of affidavits. I believe that's what's required by the law, and that's what I'm going to continue to do in every case. Nothing, no offense, nothing you're going to say until the Supreme Court or the Dallas Court of Appeals changes their rulings on this and gives me other direction. Nothing you're going to say is going to change my opinion on this. And so I'm not sure what else to say at this point other than I believe in being consistent. I think this is what's required by the law. I don't see that there's an order that's been submitted. Have you guys submitted an order yet?
I have not, Judge. I can prepare one today or have it. What I need to do is circulate it, obviously, but I'll prepare it, try to get it to everybody by Monday and try to get it to the court if that's agreeable. And then the other thing is my motion didn't deal with Exhibit F, which is attached to their response, which concerns Mark Chapman's affidavit for billing records of orthopedic specialists of Austin. I would assume that everybody's going to agree, a council will agree that this order is going to cover that as well, and that I don't have to file an additional motion. Is that agreed, council?
Don't put them on the spot. If you didn't follow it, if they want to agree to that, they can. If they don't want to agree, but I don't think it's fair to put them on the spot here.
Yeah, the only reason I bring it up, Judge, is it's a new affidavit by the same affiant concerning some other medical records. So I know, it seems like we know what the ruling's gonna be. So I guess if I need to file an additional motion, I'll file an additional motion.
Unless,
Yeah.
of course, new case law comes out between now and then.
Sure, if something
Unless
changes in the
new
law
case.
and you give it to me, I'll be glad to consider it. That seems to be the court's position, and I don't want to waste any more time than anybody else.
And Your Honor, I accept your ruling and understand your opinion in that respect. I just want to make sure so that the record is clear. The ruling is because Mr. Chapman is not a medical doctor. Is that my understanding of the ruling?
That he's not, he's not
Not
qualified to
qualified.
testify. He's not qualified to testify.
Yes, sir.
I'm not saying that in certain, like say you had a physical therapist and a physical therapist wanted to counter a physical therapist bill, then I've not had that happen before, but I would consider that. But I just don't believe he's qualified to test to
Yes, sir.
provide a counter affidavit.
Yes, sir.
All right, Mr. Lee, are you still there? You look like you're frozen. I think you froze. Okay, guys, anything else today?
No, sir.
Okay, I think Mr. Lee is frozen. I think he's gone now. There he is. Now you're muted. Typical, every possible problem you could have with Zoom just happened in the last 30 seconds. Mr. Lee, you need to unmute. I don't know what he's doing. He's talking, but he's not unmuting.
Yeah, sorry, Judge. I didn't hear anything anybody said for the last 2 to 3 minutes. I got frozen out.
Okay. I was just saying that we're finishing the hearing up, and I hope you guys have a great weekend. Just get me an order, preferably by the end of the day if you can, but if not, then you can decide whether or not it will cover the other hearing or not. If new case law comes out before this goes to trial that you want me to take a look at, I would encourage you to listen to me. If the Amarillo Court of Appeals comes out and says, this is okay, I'm not going to listen to them. I'm listening to the Dallas Court of Appeals or the Supreme Court. So I don't want to waste your time. This is what I'm doing until I'm told. I have two people that I have to, or two entities that I have to listen to, and that's the Dallas Court of Appeals and the Supreme Court. And if they come out with an opinion that says that I'm wrong, then I will definitely take a look at that. But you don't need to bring up Amarillo or Tyler or Corpus Christi or whoever until there's binding authority. Otherwise, this is what I'm doing. All right, guys.
May I be?
Someone try to speak.
I just wanted to be, may we be,
You may be excused.
Thank you,
Thank
Judge.
you, guys.
again, everybody.